Good morning, please be seated. All right, we're ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Mr. Smith, you may proceed.
Your Honor, at this time, we call Deputy Eddie Duran to stand. I would remind the court he was not sworn earlier.
Yes, sir. All right, remain standing, raise your right hand, Madam Clerk, swear the witness.
You swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Please be seated. And as you've heard many times, direct your voice to the microphone in front of you, speak clearly and distinctly so we can all hear and understand you.
Yes, sir.
And the court reporter is able to make a good record.
Yes,
And if there are any objections, stop speaking until you receive an instruction on how to proceed, okay?
Yes, sir.
All right? Granted.
Please state your full name to the court, please.
It is Eddie Lee Duran, Jr.,
And spell your last name.
D-U-R-A-N.
And prior to May 3rd, 2024, how were you employed?
Prior to then, I was with the Altus, Oklahoma Police Department.
No, I'm sorry, on May 3rd, 2024.
On May 3rd, I
how were you
apologize, sir. I was
employed?
employed at the Okaloosa County Sheriff's Office.
For a few minutes, I'd like to talk to you about your education and preparation for your work in law enforcement, and I think you anticipated my next question. Would you share with the court your prior law enforcement experience?
I began military police in the United States Army in 2006. Once I got out of the military, I went to the Altus Police Department in Oklahoma. After that, subsequently moving to Florida, I was employed with the Okaloosa County Sheriff's Office.
And in preparation for your work with the United States Army, what year was that you were in the military?
I went in 2003, ETS in 2014.
And while you were there, you became a member of the, what's called the MPs?
Yes, sir.
What was your training for the military police?
It was approximately 3 months or so of advanced individual training consisting of what would be comparable to a police academy.
When you came out of the Army and you became employed in Altus, Oklahoma, explain to the court what you were required to become certified as a law enforcement officer in the state of Oklahoma.
I attended Academy, which is the Council of Law Enforcement Education and Training, also known as CLEAT, which is the state certification. Academy consisting of approximately, I want to say, 540 hours.
And did the 540 hours include training directly related to such matters as use of force by police officers, best practices by police officers, and that sort of thing?
Yes, sir.
And how long were you with the Altus Police Department?
Approximately from early 2015 until, I would say, mid-2019.
And what were your assignments or your principal assignments when you were with the Altus Police Department?
Initially, I was a patrol officer, and then eventually was a canine officer for the department.
And when you came to Florida and came to this area, how did you obtain your job with the Okaloosa County Sheriff's Office?
Initiating the application process, and then once accepted, coming in as an employee.
Now, I think I may have skipped something here. As a result of the 540 hours, were you a certified law enforcement officer in the state of Oklahoma?
Yes, sir.
And if you would tell the court, how did that certification affect the training that you received upon your application for employment with the Okaloosa County Sheriff's Office?
Yes, sir. Being certified in the state of Oklahoma, it was essentially reciprocity. I had to come into the state of Florida to pass the Florida law, which is essentially equivalency of training, Florida law, self-defense, driving, firearms, self-defense stuff. Yeah.
And the equivalency training that you received in this state, was that the same or similar to the training that you had received for the law enforcement certification you had obtained in Oklahoma?
Yes, sir.
And did you complete your training here?
Yes, sir.
The training that you received in the equivalency training, which is, if you will, the short course. Mm-hmm. At the short course, did they talk about specifically issues related to use of force, defense, use of defense by a law enforcement officer, that sort of thing.
Yes, sir.
And did you get employed by the Okaloosa County Sheriff's Office?
Yes, sir.
And what was your principal assignment there?
Initially, I was a school resource officer for Choctawhatchee High School, and then I came back as a road deputy.
And were you required to be certified in the state of Florida?
Yes, sir.
And because of the equivalency test results, were you certified in the state?
Yes, sir.
In addition to the training you received for your certifications in Oklahoma and Florida, did you have an obligation at the Okaloosa County Sheriff's Office to continue your education and training?
Yes, sir.
And did that include a requirement of so many hours a year for you to continue your employment and retain your certification?
Yes, sir.
And did you do that?
Yes, sir.
And did you have records of your training and your attendance at training regularly kept by the department?
Yes, sir.
And at any point in time, were you delinquent or behind in the update of your training within the Okaloosa County Sheriff's Office?
No, sir.
And did you have a principal supervisor who was to assure that you did your training and maintained an updated training?
Yes, sir.
And who was that?
I had two supervisors, sir. One was Corporal Casey Dew, and the other was Sergeant Garrett McCoy.
Now, the training that you received at the Okaloosa County Sheriff's Office and at any training you'd had before that, did that also have to do with sometimes what's called situational training or scenarios?
Yes, sir.
Tell the court what a scenario is in terms of when an officer is being trained about uses of force.
Utilizing whichever training method the department had at the time, we would be put in certain situations so that we could grow accustomed and learn how to adapt and essentially handle or deal with whatever situation we were put in.
And did your training even include things sometimes called shoot, don't shoot scenarios?
Yes, sir.
And explain to the court what a shoot, don't shoot scenario it comprises.
Essentially, sir, what it's going to look like is we'd have a target that we would be required to observe within a matter of time, and then within that reasonable amount of time, make a decision whether or not it was a subject or a victim or whatnot, or, you know, whether we were going to fire the firearm or not.
And as part of your training, did you also have a requirement for actual target practice and updating of your skills with a weapon?
Yes, sir.
And did you have an assigned weapon that you used when you were with the Okaloosa County Sheriff's Office?
Yes, sir.
And would you tell the court what that was?
It was a SIG P320 semi-automatic pistol.
And from your observation of yourself and other officers, is that a common police officer, weapon used by police officers certainly in Florida?
Yes, sir.
And did you stay updated on your, did you have requirements that you had to have so much time on the range and practice in Florida annually?
Yes, sir.
And did you stay updated on your firearms requirements?
Yes, sir.
As part of your firearms training, did that include training what you've described as not only target shooting, but also when to shoot and when not to shoot?
Yes, sir.
In your training at the Okaloosa County Sheriff's Office, or in fact even in Oklahoma, had you received specific training addressing the issue of responses to what might be called domestic disturbances?
Yes, sir.
Tell the court the kind of training that you received both in Oklahoma and here as to problems associated with domestic disturbances responses.
During the training in any essentially basic academy, but specifically towards me, we were put in scenario-based training, responding to domestic situations, being role players. And of course, in that training itself, we were taught obviously that there are several different scenarios or events in law enforcement that are more high risk than others, one being traffic stops, two being domestic violence situations.
And prior to May the 3rd of 2024, were you a road patrolman, a deputy in Okaloosa County?
Yes, sir.
And had you had experience yourself with responses to domestic violence or disturbances.
Yes, sir.
And did you find them, from your own experience, to be more difficult responses?
Yes, sir.
Among the kinds of things you're required to do?
Yes, sir.
And in your training with the Okaloosa County Sheriff's Office, was it brought to your attention difficulties that this specific department had had with officers being injured or worse in domestic disturbance responses?
Yes, sir.
And what were you taught about the dangers of domestic responses in this county?
Specifically that regardless of whatever scenario we were put in as far as domestic violence goes, it is going to be, again, one of the most dangerous calls that we would receive, but also that we had deputies in the past that were killed in the line of duty.
In Okaloosa County?
Yes, sir.
In domestic disturbances?
Yes, sir.
I now want to address yourself, but look, before I leave that. In your employment as an MP, or in Altus, Oklahoma, or in Okaloosa County, Florida, prior to May 3rd, 2024, had you ever received any allegations for use of excessive force?
Your Honor, object.
Please approach.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Overruled, you may proceed.
My question was, have you ever received any complaints or discipline or allegations for use of force in any of the departments in which you have served?
No, sir.
And could you estimate, and I know it might be hard to do, just give the court some sense of how many domestic violence or disturbance responses you had had over the course of your employment?
Honestly, sir, that's not a number I'd be able to give.
More than 10?
Probably well over 50 more. I couldn't tell you specifically.
I want to now draw your attention to May the 3rd, 2024. Okay?
Yes, sir.
Please tell the court what you were assigned to do and what your duties were on May the 3rd, 2024, before you received a dispatch to go to Elan Apartments.
I was assigned to the Central District of Okaloosa County, being specifically assigned to Zone 17 in the Fort Walton Beach. So essentially just going to be patrol, answer calls for service, assist any of the officers or deputies that needed it.
Now, Zone 17, just back for a little information, your assignment as officers are to zones, and those zones represent a geographic area, correct?
Yes, sir.
And could you tell the court what, in general terms, where Zone 17 was located in Okaloosa County?
Yes, sir. It would be in a section that encompassed Beale, Herbert Road, Martin Luther King, all the way down to Mary Esther Cutoff.
And to be clear, was Zone 17 a place, was Elan Apartments located within that zone?
No, sir.
Do you know why you received any kind of a dispatch that day to do something at Elan Apartments when you were in a different zone?
We had received an abundance of calls, and the zone deputy at the time was working on a different call.
What zone was Elan Apartments in?
16, sir.
So was that adjacent to your zone?
Yes, sir.
Okay. So you received a dispatch to go to a zone other than the one that you regularly occupied?
Yes, sir.
And did you follow up on that?
Yes, sir.
The court has already heard played the dispatch you received that day, but to the best of your recollection, tell the court what you recall, information you received, and how you received it.
Received a call through the radio and as well as through the computer stating that there was a...
Let me stop you there for a second. Explain to the court how you received dispatch calls. I kind of jumped a step. There are more than one way. Explain to the court how you normally would receive a dispatch as a deputy on patrol.
Initially, it would be through the radio, and then information that would come through the computer in the vehicle would start to populate, but the initial call was, to the best of my recollection, a recollection is I can't think of the word. I just blanked out. I apologize. Anyway, it was a disturbance in progress that had become physical between male and female.
And when you received that information, what did you believe, at that point in time, believe you were likely responding to?
A domestic violence situation, sir.
And did you agree that you would respond?
Yes, sir.
And did you respond?
I did.
Tell the court where you went.
I went to the Elon Apartments.
Now, were you wearing we already know this, but I need to ask it. Did you have a body cam on that day prior to the dispatch to the Elon Apartments?
Yes, sir.
Was it always engaged?
It was always on. It was on standby until I reached the scene, sir.
Now, when you went to the response to Elon Apartments, why did you engage your body camera?
One being agency policy, body cam would be on during all calls for service. Two, just because it is a record of what's taking place during the service.
And did you, I think we've already seen, and did you record from that body cam everything that took place after your arrival, just as you arrived to Elon Apartments?
Yes, sir.
And do you recall who you saw and why you saw them?
Initially, upon my arrival, I went to the leasing office and I made contact with two adult males in the office.
And what did, we've already seen it, but what did they direct you to do?
Directed me to the leasing agent, who was the caller, who was walking in the parking lot.
And is that the Miss Rodriguez that that was here yesterday and testified before the court?
Yes, sir.
And you've seen the information of what she told you?
Yes, sir.
What she told you was, as recorded, she talks about not only the call she had received, but also some additional experience she had had and she was concerned about at that area, correct?
Correct.
Okay. Again, now that you've received that additional information from the leasing agent, combined with what you had had on the dispatch, what did you believe you were responding to?
A physical domestic violence situation.
And what did you instruct, if anything, the woman, Ms. Rodriguez, to do as you went up to the scene?
I asked her to stand by for the deputies that were coming on the scene so that she could direct them to the apartment.
And she directed you to a specific apartment?
Yes, sir.
What was that?
1401.
And she told you which floor that was on?
Yes, sir.
Which was what?
The 4th.
And why did you decide to go immediately to the scene rather than wait for backup?
Based on the information that I had at the time and the information that I was given, I felt it was necessary for me to go forward and initiate contact to either A, prevent further crime or harm to anybody else.
And have you received previous training about when to go as opposed to not go to a particular situation?
Yes, sir.
And what was your training at the Okaloosa County Sheriff's Office that you were to do when you came upon a situation like this where you were unsure whether somebody was in harm's way or not?
It's always, we move forward and go direct threat to stop any further harm or crime.
And did you do that?
Yes, sir.
Now, I want to take you to the scene itself. How did you get up to the 4th floor?
Through the elevator, sir.
Had you ever been there before?
Briefly for other calls, minor situations.
Have you been on that floor before?
No, sir.
Tell the court what you observed when you get off the elevator. Tell the court what you did and why you did those things that you next decided to do.
Okay, so getting off the elevator, went ahead and contacted my supervisor, let him know that I was, the individual was waiting for them downstairs. Going through the breezeway, I see a long hallway, solid wall, 2 doors, approximate 4-foot rail. And then down towards the end of the hallway, there's another 4-foot rail along with the stairwell and a wall. And then I see apartment 1401. That was at the end of the hallway.
So you have a solid door to your right as you're going down the hallway?
Sir.
And to your left, you have a railing?
Yes, sir.
And you're on the 4th floor?
Yes, sir.
Okay. When you get to the door, what do you do and why do you do it?
So one of the main things that in common practice for law enforcement is prior to knocking, we would listen to find figure out what type of situation we're getting ourselves into, making sure that if there's you know, any screams or yelling or signs or, you know, sounds of physical violence. You want to kind of evaluate that prior to making presence.
Did you also consider the kind of your geography, if you will, the location you were in?
Yes, sir.
And why was that of a concern, if at all?
So when looking at where the apartment door was in consideration where the railing and where the stairwell wall was, I was what I believed to be in a less than optimal position, so having to adjust kind of where I was going to stand was something that was always in the back of my mind.
Did you stand in front of the door?
No, sir.
Tell the court why you wouldn't just stand in front of the door.
So throughout training, and again, common practice between military and law enforcement, standing in front of the door, which is called a fatal funnel, is something of a major safety concern for law enforcement officers, especially based on these types of scenarios. We're taught that we never know if there's an individual behind the door with a firearm that could shoot through the firearm, so our training dictates that we stand to the left or the right of the door, preferably on the side of the door with the handle so that it opens opposite to you.
And did you do that in this occasion?
Yes, sir.
Why did you decide to stand on the first one side and then the other?
So initially standing on one side, which is the door handle side, which is the optimal side. But again, realizing there was a 4-foot rail behind me, a wall to my back, and a long hallway with no cover, I felt maybe it was necessary for me to move off to the other side and kind of have some distance from the door, just in case there was anything to happen.
Was that consistent with the training that you had received at the Okaloosa County Sheriff's Office?
Yes, sir.
Now, when you listened to the door, did you initially hear anything?
Right off the bat, no, sir.
Now, you've been told that there's been some incidents ongoing, and now you hear nothing.
Yes, sir.
What are you thinking at that point?
There's several different scenarios that could play out, but based on my assessment and again, the information that I knew at the time, and again, on training and experience in these types of calls, having somebody who was in a physical domestic to where people could overhear it, and then minutes later there's silence, it led me to believe that there was somebody who was either in harm or was unable to come to the door for whatever specific reason.
Have you previously encountered it yourself where someone was actually kept from going to the door?
Yes, sir.
A victim?
Yes, sir.
And you had that experience yourself?
Yes, sir.
Now, once you decide to knock on the door, go through, and the court's already seen the video, but go through kind of the process you use as to the knocking and what you do and why you do it. Your first knock.
First knock, it was an initial knock, and essentially a common practice in law enforcement is to do that first knock to A, grab the attention of whomever's in the home, but B, also not announce yourself specifically at that time, the law enforcement, just to kind of ease tension or, and then gauge what type of response you're going to receive, whether it's, you know, who is it or how can I help you or anything like that, or if it's an aggressive nature being the types of scenario we always put in.
And did you hear or believe you heard any noise come back in response to the first knock, and that's the knock before you've identified yourself?
Yes, sir.
And what did you hear?
I heard profanity and then the word police.
And what did that do in terms of your consideration of your next step or stage in the process?
It led me to believe that the individual inside was aware of my presence.
And did you have a sense of whether it was a welcomed presence or unwelcomed presence?
When I heard the comments, it made me feel as though it was an unwelcome presence.
Now, was that picked up on to your knowledge, your body cam?
Yes, sir.
But was it, how loud or audible was it?
It was audible to where you could hear it, but again, it was what I heard. I couldn't speak on the rest of it.
Based on that response, what did you do next?
I moved forward to the door, knocked again, and then announced Sheriff's Office, open the door.
And when you knocked the second time, in relation to the knock of the first time, is there a difference?
Yes, sir. It was a more assertive knock.
And we've already heard it, but did you, if you will, yell or shout?
Yes, sir.
Did you get a response to that?
No, sir.
At any point in time, do you hear anybody asking who's there? What are you doing here? Anything like that? Any inquiry do you hear other than that language you had heard initially? Do you hear anything else?
No, sir.
Then after a few seconds, do you do a third knock?
Yes, sir.
What's the difference between the third knock and the previous two knocks?
It's going to be what's commonly called as a police knock. Again, more assertive, more audible knock.
And that's the third call, the third knock at which you're yelling, again, identifying yourself as being with the sheriff's office and requiring the door to be open.
Yes, sir.
Okay. Tell the court what happens next.
After making the third knock and the second announcement, again, I had positioned myself to the original place, again, based on what I thought would be the best case scenario for safety. The door began to open.
Let me stop you right there.
Sir.
Where's your weapon at that point in time?
It's holstered, sir.
And when you say it's holstered, we saw a picture. How is that gun particularly holstered?
In the holster itself, it is locked in place. That has a thumb brake that's a cover that you'd have to push forward, and then a thumb release that you have to go ahead and
Have you
push.
done any of that before that door is opened?
No, sir.
Tell the court what happens next, what you observe.
So as soon as that takes place, the door starts to open, and again, I'm bladed off along the door frame, and I'm looking out towards the door, and as soon as the door opens, I see the individual.
And when you see the individual, have you been trained on the way you were supposed to take an initial observation of someone?
Yes, sir.
Tell the court what your training is as to the way in which you are to initially observe someone who may be an assailant and may not be.
So when you make contact with somebody, you generally, again, training and common practice in law enforcement is you look at the person's eyes, you look at the waistband, and then you look at the hands.
And that's the process you are taught to follow, at least.
Yes, sir.
Did you follow it on that occasion?
Yes, sir.
What did you see when you looked at the person's eyes?
So initially, when he opened the door and I saw his eyes, I saw frustration, aggression, and overall just not too excited for my presence to be there. And then again, looking at his waist, that's looking for any weapons that may or may not be visible, and then of course his hands, and I see a firearm.
And when you see the firearm, in what position is the firearm?
Initially, the firearm's in a upward canted position.
Are you familiar with a term called cantered?
Say it again, sir.
Cantered?
Yes, sir.
Tell the court what that is and how you're taught, what significance that is in your teaching.
So looking at the positions, if you're going to shoot, your arm's either going to be straight down or it's going to be in an upward position, depending on the angle or position that you're specifically in.
Now, we know that all this is happening in a matter of parts of a second, correct?
Yes, sir.
At that point in time, when you see the weapon, what goes through your mind?
I'm dead. Dead. I'm about to be shot.
And what do you do in response to it?
I drew my firearm and I shot him.
I want to back up just for 1 second. Did you give him any direction?
When the door opened, I directed him to step back.
And which direction did he step?
Forward.
Now, just to be clear, we've seen the video, and you've watched it several times, I'm sure.
Sir.
Did you actually see, could you actually see the gun even before it shows up on the video?
Yes, sir.
Tell the court why that would be.
Standing in the doorwell or the door jamb and my body being bladed off to the side creates, one, a smaller target. Two, it creates an angle to where I can see what's going on in the doorway when it opens, as opposed to standing in front of the doorway, entirely in front of the door. And it just causes for me to be able to look past the corner and see the individuals that are coming through the door prior to them seeing me.
When you fired your weapon, could you estimate for the court how far away that you are from Mr. Fortson?
approximately 4 feet.
And have you received training in what's called close encounters, if you will?
Sir.
Tell the court what your training tells you about the importance of the distance you are from someone and the use of force that you employ.
So being trained with reactionary gap, meaning reactionary gap optimal would be somewhere between 20 and 25 feet, where you have options to either speak to someone, give commands, or depending on the scenario or whatever is going on or whatever is in the individual's hands, give you an option as far as the use of force.
And do you have a specific, does Okaloosa, to your knowledge, train and have a policy if you are within 6 feet regarding resistance?
Yes, sir.
And how you are to proceed as an officer?
Yes, sir.
Tell the court about that.
So anywhere between 4 to 6 feet is going to be considered a very dangerous reactionary gap. It gives you very limited time to see what's going on, understand what's going on, and then react to what's coming your way.
And did you, at all stages in this process, up to that shooting and including the shooting, did you try to and adhere to the policies that you had been taught by the Okaloosa County Sheriff's Office?
Yes, sir.
And was that consistent with, frankly, with your own experience at that department and elsewhere?
Yes, sir.
Now, once you fire, you remember how many times you shot?
5 times, sir.
What happens next?
After discharging the firearm, Mr. Fortson was on the ground, and then I initially started giving commands to drop the gun.
Could you see the gun at that point?
No, sir.
Were you able to discern after that why you couldn't see the gun initially?
Yes, sir.
Tell the court why you couldn't see the gun initially.
When Mr. Fortson fell backwards onto the floor, he was initially on his side, the firearm being in his right hand. He was on his right side.
Have you been trained as to what you're to do when someone still has a weapon or may still have a weapon involved?
Yes, sir. It's to, again, maintain officer safety, issue commands, and to, again, just give commands to either drop the weapon or stop moving or just stay in a oriented posture.
And we've heard what happens afterwards. You remain in that position until backup arrives?
Yes, sir.
And when you went down the hallway, I think this carries it, you kind of slammed in the wall and frankly said the F word. Do
Yes,
you
sir.
recall that?
Yes, sir.
What was happening then?
I felt every emotion I think anybody could possibly feel all at once. And then again, most importantly, that was something that I never, ever wanted to happen while working. I don't think any officer does. And I just hated it, and I didn't want it to happen. And I was scared, angry, frustrated, frankly terrified at the thought of I was just put in a scenario where I, may not be alive anymore.
One moment, Your Honor. Just 1 second, Judge, please.
Yes, sir.
I think I'm almost there. Looking back today, in light of your training and background, do you believe that you followed the instructions and the training that you had received throughout your career?
Yes, sir.
And at the time you fired, were you Were you afraid that you were about to lose your life?
Absolutely, sir.
Attend to the witness.
Mr. Duran, the call that you initially received over the radio indicated physical disturbance, male and female, correct?
Yes, sir, I believe so.
It did not indicate that it was domestic violence, did it?
It indicated physical altercation that had become physical.
It did not indicate domestic violence, did it?
It indicated physical, an issue that had become physical, sir.
It did not indicate domestic violence, did it?
Again, sir, I can only speak to it. It said argument that had become physical.
So it did not indicate domestic violence, did it?
Ask and answer.
It's been asked, it hasn't been answered.
Overruled.
It did not indicate domestic violence, did it?
Specifically, no, sir.
Okay. And male and female does not necessarily mean domestic violence, correct?
That's not something I'd be able to speak on, sir.
You don't know what domestic violence is?
I do know what domestic violence is, sir.
Okay. So you understand that it means a spousal relationship, a child in common, related by blood or marriage. You understand what domestic violence
Yes,
is,
sir.
don't you?
Yes,
Okay.
sir.
So you understand that male and female does not necessarily indicate domestic, correct?
Again, sir, I can't speak on it. I can only go off of the information that I had at the time.
Well, that wasn't my question, sir. You understand that male and female does not automatically indicate domestic, correct?
Correct, sir.
Okay. And it did not indicate, the information that you received did not indicate which party was being physical, correct?
Yes, sir.
It just said physical disturbance.
Yes, sir.
Okay. And you'd agree that physical disturbance is a pretty vague description, correct?
Sure.
And it could mean a lot of things.
Yes, sir.
Anything from something fairly minor to very serious.
Yes, sir.
And it was also conveyed to you that that was fourth-party information, correct?
I believe so, sir.
Okay. And you understand that fourth-party information is, can be very inaccurate.
Again, sir, I only respond to the information that I'm given at the time.
I understand that, but
Yes, sir.
do you understand in general, fourth-party information is typically not very reliable?
Again, sir, as a law enforcement officer, I don't have the luxury of speculating on that. I only have to respond to the information that I have at the time.
I understand that, but in general, do you understand fourth-party information to be inherently reliable?
Again, sir, in experience, I can't speak on that. I only have to go off of what I have and then understand the situation as I arrive on scene.
I understand that, but again, my question is, in general, do you believe fourth-party information to be inherently reliable?
Sir, again, fourth-party information is going to be dictated when I arrive on the scene.
That wasn't my question, sir. Do you understand, in general, fourth-party information to be reliable and accurate?
It just depends on the entire situation, sir.
But in general, the more direct source you have of information, the more reliable it is. You understand?
Yes, sir.
So second part, a direct witness is more reliable than third party, correct?
Sure.
And third party would be, in general, more reliable than fourth party information.
Sure.
Okay. Now, when you arrived at Roger's door, and you listened, and you said you didn't hear anything, correct?
Yes, sir.
And you indicated that that silence concerned you, and you thought that maybe somebody may be injured.
Yes, sir.
Okay. Silence could also mean that nothing is happening, correct?
It could be, sir, yes.
And your first knock at the door, you did not, as we saw, did not indicate law enforcement for the reasons you gave. Are you aware that when you knock on the door and don't announce yourself, that someone may be apprehensive because they don't know who's at the door?
Again, I can't speak on the individual that's at the door, sir. All I know is that when I knock on the door, we initiate or wait for a response.
All right, but that wasn't my question. You're aware that when you're knocking and not announcing, the person inside has no way to tell if you're law enforcement, correct?
Correct.
And that may cause the homeowner to become concerned that there is an unknown person at the door, correct?
Again, sir, I can't speculate on that. I don't know what was going through the individual's mind at the time.
I'm not asking you to. But are you aware that in general, that the part of your purpose there is to not let the people know that you're law enforcement, correct?
My purpose was not to not let them know, sir. That's not my purpose at all.
But you intentionally didn't announce, correct?
I announced myself, yes, sir.
The first time?
No, sir.
Okay, that's my question. You intentionally did not announce yourself as law enforcement, correct?
Correct.
And that the person, however many people inside the home, do not know you're law enforcement, correct?
Again, I don't know that, sir.
Well, how would they know if you haven't announced?
I couldn't tell you, sir. Again, I can't speculate on that.
I'm not asking you to speculate,
Well,
but
any
you
answer-
haven't given them any information that you're law enforcement, correct?
Correct, sir, but I don't know if the person was at the door. I don't know if the person was aware something was going on. It's not something that I have knowledge of.
Right, but
I
you're
only know-
intentionally
the
trying
only-
to prevent them from letting you know you're law enforcement, correct? That's the purpose.
Again, the only knowledge I had was what I knew at the time, sir.
I'm not asking you
Again,
that.
knocking on the door, again, which was consistent with training, consistent with experience, it's just something that was done. That was
But the
done.
goal is, as you said, to calm the situation down, is to not announce yourself as law enforcement, correct?
Correct.
And are you aware that the person, if they don't know you're law enforcement, that they may become more apprehensive? Is that a factor you consider?
That's not something that I've considered, no, sir.
Okay. Now, when you heard the voice from inside, the voice was muffled, correct?
It was clear to where I could hear it, yes, sir.
But you don't know exactly what the person said, do you?
It was profanity with the word police, sir.
Okay. But you don't know the entirety of that sentence, do you?
I only know what I heard, sir, and it was the profanity with the word police.
Okay. So you don't know what the rest of were they asking a
Objection, Your
question?
Honor. He has answered that question.
I haven't heard the answer. Go ahead.
You don't know the entirety of that sentence or statement, do you?
No, sir, again, my answer is I only know the profanity and the word police.
Okay. So could it have been a question?
I don't know, sir.
Okay. You don't know?
I don't know, sir.
And at the time that you heard that, you are standing, as we saw, down the hallway away from the door, correct?
Correct.
So the person would be unable to see you.
Again, I don't know, sir. I only know what I heard, and that was it.
Well, you understand that the person can't see you through the wall, correct?
Correct, sir, but I can't speak on what was going on inside the home at the time.
I know that, but you're intentionally out of sight when you hear that voice, correct?
Yes, sir.
Okay. And at this point, you have not announced yourself.
No, sir.
So the person hasn't heard your police and can't see you when they say what you heard, correct?
I guess so, sir.
And there were no windows, correct?
No, sir.
The person can't look out the window.
No, sir.
And as you said, you're on the 4th floor, correct?
Yes, sir.
So you understand that the person can't see your patrol vehicle?
Yes, sir.
And you did not use your siren in going there, did you?
No, sir.
You did not activate your blue lights?
No, sir.
So they wouldn't have heard approaching police sirens?
Not that I'm aware of, sir.
And whoever's in the home would not be able to see your vehicle in the parking lot?
Not that I'm aware of, sir.
And you don't know, you saw there was a peephole, I'm assuming?
Yes, sir.
Okay. You don't know if anybody looked through the peephole?
No, sir, I couldn't tell you.
And if they did, you don't know when they looked through the peephole?
No, sir.
And when you're announcing yourself multiple times, you don't know what the people inside can hear, correct?
Again, I couldn't tell you, sir.
Okay. You don't know where the people may be located in the apartment?
No, sir.
Okay. You don't know if they're hard of hearing?
No, sir.
You don't know if they're wearing headphones?
No, sir.
So when you announce sheriff's office, you're aware that that doesn't mean that the person hears it, correct?
Again, announcing is something that we're required to do. If the person hears it or not, again, the scenario is going to change.
I understand, but you're aware when you announce, that doesn't mean that whoever's in the home has heard it, correct?
Sure.
And you had no idea how many people in the apartment?
No, sir.
You didn't know the relationships of anybody in the apartment?
No, sir. I only knew what I knew at the time.
And you did not know that the voice you heard was the person that opened the door, do you?
No, sir.
And again, we covered, it was reported to you as a male and female, correct?
Yes, sir.
But you'd agree that a male can be a victim of a physical disturbance, correct?
Yes, sir.
And a male can be a victim of domestic violence?
Yes, sir.
And if a male is attacked in their own home, or even, you know, any place they have a right to be, do they have a right to defend themselves?
Sure.
And that can include grabbing a weapon, correct?
Sure.
Can include grabbing a gun.
100%.
So, as the person opened the door, you had no idea the person could have been a victim of domestic violence, correct?
No, sir.
No, you don't believe they could have been?
Again, I don't know. I only know what I knew at the time, sir.
Right, but the person could have been the victim, correct? The person opening the door?
It could be a probability, yes, sir.
Okay. Now, you said you saw frustration and aggression in Roger's eyes. Was that part of your reasoning to shoot him?
No, sir.
That was not part of your justification?
No, sir.
So it played no part in your
It was an
analysis?
assessment that I make and a lot of law enforcement officers make as they initially come in contact with an individual.
Okay. But that was part of your reason for shooting, correct?
No, sir.
Okay, maybe I'm confused. You said you took that as an aggressive act. He looks aggressive, he looks frustrated. You didn't, and that played no part in your shooting him?
No, sir. I've dealt with thousands of people that look at me aggressively that had no play in it specifically.
And you said he stepped forward and did not comply with your orders.
Yes, sir.
You told him to step back,
Yes, sir.
and your position is that he stepped forward and did not comply with your orders?
Yes, sir.
And was that also part of your reasoning in shooting Roger?
That along with the firearm, sir.
But that was part of your reasoning for shooting them, that he wasn't complying with your orders?
It was the firearm and stepping forward, yes, sir.
And in your affidavit, you described Roger as an assailant. Do you believe that Roger attacked you?
Using the word assailant, sir, was something that I have commonly used in any type of interview, just as a general description.
Right, but it's a general description of someone attacking you.
Correct.
Okay. So do you believe Roger attacked you?
Considering I gave him a command and moved forward with the firearm in his hands, yes, sir.
Now, I believe I don't want to misquote you here, I believe you said that when you first saw the firearm in Roger's hand, that it was an upward canted position. Is that correct?
Yes, sir.
Okay. Can you sort of demonstrate for me what you're talking about?
Would you like me to stand, sir?
Yes, please. Yes, sir.
So, his hand was here.
And for the record, you're holding your arm at sort of a 45-degree angle?
Give or take, sir, yes.
And that's what you saw as Roger begins to open the door?
Yes, sir.
Was that, the gun being in that position, was that also part of your justification for shooting Roger?
Yes, sir.
And so your position is that he then moved the gun back pointing at the ground before you fired?
Again, sir, everything happening in fraction of a second, I can only speak on to what I saw initially and then what my reaction was.
Okay. But on the video, we see the gun is pointed down, if you'd agree?
On the video, yes.
Okay. So your position is that the gun was tilted forward, and then as you began to fire, he pointed the gun back at the ground?
Again, sir, what took place in that fraction of time is not consistent with what you see on the video.
Okay.
What I saw and observed at that specific moment in time was the firearm in a separate position than what you observe on the camera.
Okay. So then he moved it back towards pointing at the ground, correct?
I guess that's what he did, sir, yes.
Okay. Just as the camera panned down?
Yes, sir.
So he was moving the gun back towards the ground as you fired?
Again, sir, initial
Not
contact,
towards you,
seeing the
correct?
firearm in a canted position, which caused my reaction, which is based on training, right? So again, responding to what I initially observed and no longer seeing what's going on down here, but focusing on the individual in front of me.
Now, you stated that you had followed your training from the Okaloosa County Sheriff's Office, correct?
Yes, sir.
Okay. But they did not agree and they fired you, correct?
Objection, Your Honor.
Please approach.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa.
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Overruled.
Mr. Duran. Sir. You had stated that you acted in accordance and followed all the policies of the Okaloosa County Sheriff's Office, that you were ultimately fired by the Okaloosa County Sheriff's Office, correct?
Yes, sir.
Okay, after a finding by Attorney Ferris?
Yes, sir.
Okay, all right, thank you, sir. Those are my questions.
Redirect.
May it please the court. You were asked a question regarding fourth party, that this was a fourth party report. Do you recall that?
Yes, sir.
When you arrived at the Elon Apartments, you met with Ms. Rodriguez, correct?
Yes, sir.
Did Ms. Rodriguez specifically tell you not only of what had been reported to her, but also of that which she herself was concerned about?
Yes, sir.
That had happened there a couple of weeks before?
Yes, sir.
And the fact that Ms. Rodriguez gave you that information at the scene, did that have an impact upon your decision to go up?
Yes, sir.
You were asked a question about whether or not this meant domestic violence. I want to go back to what you were thinking at the time. You were dispatched to an ongoing disturbance involving male and female, correct?
Yes, sir.
Now, male and female, when you got there, you realized that there was only one apartment involved.
Yes, sir.
So one apartment involved, male and female, ongoing disturbance is the information you had before you went upstairs.
Yes, sir.
To you, on your experience and training, did that indicate to you that this could be a domestic disturbance?
Yes, sir.
You were asked about could the male have been the victim of a domestic disturbance, you recall?
Yes, sir.
You have gone to domestic responses a number of times.
Yes, sir.
Male and female can be victims.
Yes, sir.
The person who answered the door was the person holding the gun.
Yes, sir.
At any point, would that make you think that was a potential victim?
No, sir.
You announced twice out loud and yelling loudly that you were with law enforcement and for them to open the door, correct?
Yes, sir.
And it was in response to those out loud, loudly announced and pronounced announcements that the door opened.
Yes, sir.
Almost immediately after the third one.
Yes, sir.
Now, you were in the apartment and the size of the apartment, correct?
Yes, sir.
You actually got a chance to see it.
Yes, sir.
Would you describe it as a large?
Stay behind the lectern so we get a good record with that microphone.
Thank you,
please.
Judge. I tend to wander. Would you agree that it's a small apartment?
Yes, sir.
Would you agree that I'm at a distance now, maybe 10 to 20 feet from you?
Yes, sir.
Would you agree that this was approximately, you heard witnesses yesterday on this, but this would be the area that was likely where he was standing from the door?
Yes, sir.
The last announcement, it's within 3 seconds, I believe, that he opens the door.
Yes, sir.
Okay. Any doubt in your mind, at least in your mind at the time, that he had heard and adhered to was responding to your announcement that you were with law enforcement and to open the door?
No, sir.
You were asked about the process of aggressive looks, et cetera, correct?
Yes, sir.
You said that that was not what made up your mind.
Correct.
You were asked about did it have any impact? What was the thing that caused you, when you first looked at his face, have you looked at people's face when they were aggressive before?
Yes, sir.
Have you seen them when they look mad at you before?
Yes, sir.
Angry before?
Yes, sir.
Do you pull your gun then?
No, sir.
What caused you to pull and fire your weapon?
Being surprised with a firearm at the door, sir.
You know that there was a peephole.
Yes, sir.
You know that the peephole, you don't know whether or not somebody came to or saw you.
Yes, sir.
But it was after the first knock that you heard the language that you've described for the court, correct?
Yes, sir.
So the word police and some other, what sounded like profanity, were forthcoming before you ever announced that you were there.
Yes, sir.
You were asked whether or not it could have been somebody else in the apartment or anything like that giving the acknowledgement. The language, the person you heard come to the door, did it turn out that was the only person in that apartment?
Yes, sir.
You were asked about whether you followed your instructions and followed the policies and procedures that you had been taught.
Yes, sir.
Do you believe that to be true?
Yes, sir.
You were terminated for a policy violation, correct?
Yes, sir.
But let's be clear, you did not contest that termination.
Yes, sir.
Would you tell the court, had you already determined that you were leaving the department?
Yes, sir. Prior to the events of May 3rd, I had already initiated a resignation letter so that I could leave law enforcement as a whole, just to spend more time with my family. And then the district captain had given me a call and requested that I stay on a little bit longer until they were able to receive another deputy to replace me.
And you agreed to stay on?
Yes, sir.
But you were already leaving?
Yes, sir.
Do you today, as you talk to this court, do you know of anything you did? Do you recognize anything you did that was inconsistent with the training that you had received?
No, sir.
One second, Your Honor. I want you to, for just a moment, if the door opens and you don't see a weapon, does this ever happen?
No, sir.
If the door opens and he's aggressive and using language you don't like, but there's no weapon, does this happen?
No, sir.
What was the only thing that prompted you to pull your gun and fire it that day?
The firearm, sir.
And why were you concerned about the firearm?
As soon as I saw it, I immediately thought, I'm about to get shot and I'm done.
Nothing further.
All right, you may step down, sir. Your next witness. Well, it's 10:30. Let's take a short break at this point. 10 minutes.
All right.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Please be seated. Your next witness, Mr. Smith.
Call Louis Cleam. And Your Honor, he was not here and sworn.
Say again?
He was not here and sworn.
All right. Raise your right hand, please. Madam Clerk, swear the witness.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Please be seated. Direct your voice to the microphone you see in front of you.
Yes, sir.
Speak clearly and distinctly so we can hear and understand you. And the reporter in the back of the courthouse is able to make a good record, okay?
Yes, sir.
If these lawyers object, which is likely, stop speaking until you receive an instruction on how to proceed.
Yes, sir.
Would you please state your name and spell your name for the court, since Louis can be spelled different ways?
Yes, sir. It's Louis Cleam. Louis is Lewis. Cleam is Kliem.
And would you share with the court your current business address?
I'm in Fairfax Station, Virginia.
And by whom are you currently employed?
Force Science.
And we'll go into that in a minute, but just tell us a little bit about what your current position is with Force Science.
It's from the president and also the director of the consulting division at Force Science.
And where is Force Science headquartered?
They're headquartered out of Minnesota.
And just to kind of, as a starting point, would you tell the court the kinds of services that Force Science provides to its clientele?
Sure, we have 4 divisions. The first division is a research division where we look for a variety of opportunities to conduct or to fill gaps in human performance areas. So if we look at the police industry or the civilian use of force industry and we recognize that there's an unanswered question, we're going to conduct some research to answer those types of questions, usually speed, usually descriptive research type things, like how fast can somebody move from point A to point B, how fast can I draw a gun from a holster, not a holster, those types of research. We have a training division where we teach de-escalation training. We teach force encounters training where we teach how to investigate force encounters. We have a advanced instructional methods where we teach people the science of learning and how to instruct and how to learn. I conduct customized courses for attorneys, for judges, for community members, for universities, and of course for civilian populations on how to analyze, investigate, and ultimately prosecute or defend force encounter cases.
Do you also provide services directly to law enforcement agencies?
We do, and my particular division is the director of the consulting division. My consulting is both litigation consulting, where I work with attorneys in how to investigate and prepare cases on both sides, prosecution, defense, civil, and criminal. But we also work with agencies in doing policy audits, training audits. So we'll come in after an event, we'll work with them on evaluating that event and kind of do lessons learned after action reviews. If there's not a specific event, we'll just come in and we'll help guide policy development. I specifically that work.
And the law enforcement audits that you perform for law enforcement agencies and the consulting services that you provide from your division, does that include looking at the policies that exist and recommending changes or new policies be adopted or adapted?
Correct.
And does your division also engage in the review of the training programs provided to law enforcement agencies as it relates to law enforcement officers' uses of force?
We do.
And does part of the training that you review include programs and scenarios showing and regarding the best uses of force and the best deployment of forces by law enforcement officers?
I'd stay away from the word the best. We're looking for reasonable practices. We're looking for consistent practices. When we're analyzing their training programs or their policies, what we're trying to do is compare what do we know that the law requires. Policy is more than just law. It's risk, benefits, and trade-offs of a lot of different concerns, financial concerns, personnel concerns, equipment concerns, and legal concerns. So it's a risk balance. And so part of our analysis is to determine if your policy is intentionally more restrictive than the law would require, or if it's restricted because you believe that's what the law requires. And so we work with them to just essentially ask and answer those types of questions.
And as part of the recommendations that your division makes based on the information that you've gotten from the research division of the organization?
Some of it can be, and it's not just, I want to be very clear, our research really covers 30 different peer-reviewed research projects. We draw from across multiple industries, so aviation, traffic, sports. So the largest bulk of the information we rely on is from multiple industries, not just our own in-house research.
And your division, does it rely on actual science and actual research performed by other divisions and other sources of information for the recommendations that you make?
We do rely on that, yes.
In your research, as a starting point, in your research and your consulting services that you provide to law enforcement agencies, have you found some degree of public misunderstanding or confusion regarding action, reaction, and risks associated with the uses of force by law enforcement agencies and officers?
Right, almost every case, that's what we expect to find. And that's because it's our experience, my experience, that most people are educated on violence from TV, right? And so we have very little trouble with the agencies themselves. Once we ask the right questions, they almost always have the right answer. It's just a matter of reminding them of what the question we're actually asking and answering is. And if I could give a great example of that, one that we frequently see, is this idea of, there's two main ones. One, if we talk about how far somebody is from you, if they're 15 feet away, a lot of people, jurors who've just come from the community, imagine that's pretty far. And what we can demonstrate to them is about 1 second of travel time at a sprint. And we start to then compare, like, your understanding of what 15 feet looks like to you is very different to people who are familiar with the reality of violence and speed, time, and distance. The second biggest one we see frequently is where a police officer suspects somebody might have a gun, for example, usually on a traffic stop. I'll use that example. A hidden hand where they think that person might have a gun, and so they'll draw their own gun and they'll point it and they'll say, "Show me your hand." What we can then demonstrate is, as soon as that person starts to initiate movement, it's about an average of a quarter of a second that they can present and fire that gun. Most people looking at that think that if I point my gun at that driver, I have the advantage, I have the drop on him. we can demonstrate through our research and other research, and just through years of experience watching these things, both in real life and simulations, and the cases we evaluate, that your response to that stimulus is going to be after it, and that you're going to, they're at best trade bullets. And then when we give them that information, they can then adjust their tactics accordingly. So we just provide them the reality of time, distance, and speed, action versus reaction, and then allow them to adjust their tactics accordingly. If we do that with police, we have to also do that with community members who ultimately end up on jurors.
And this may be an unfair question. If it is, just tell me it's too much. And could you tell, in the last, say, 5 years, how many law enforcement agencies that Force Science has provided the kind of services that you and your divisions provide?
Formally and informally, it's been hundreds. I would say informally, it's been hundreds. We get those calls. That's what I do full time. So we're constantly getting those calls over the last 5 years. I would personally have gotten, hundreds of those types of calls. But we also, because we do conference presentations and keynote presentations, when I say hundreds, it's because almost every conference presentation or keynote, some leader from the industry is going to come and ask a question. Our policy says X. Based on the research we've seen, is that policy consistent with what you're seeing across the country? So formally doing an evaluation where they want a full audit, and they want to report, and they want to sit down and do committee meetings, those are less frequent. There's maybe 5 of those that I've done in the last couple of years, because those are time intensive for both the agency and for us. But the more informal, constant questions, that's just a constant weekly occurrence for me.
For a moment, let me digress and talk to you about your education and past employment history before you undertook the responsibilities that you have at Force Science, all right?
Yes, sir.
Let's start with telling the court about your education, your formal education starting from high school.
From high school?
Yes.
I went to high school, graduated at 17, went to junior college, got an associate of applied science. Went from there, I got a bachelor's degree in crime and delinquency studies. From there, I got a master's degree in criminal justice administration. I got a law degree, obviously a Juris Doctorate, and then I have a postgraduate law degree in LLM, also with my capstone being in police legal advising.
And just to be clear, where did you get your law degree?
My law degree is at Washburn University in Topeka, Kansas.
And where did you get your LLM?
LLM was in Charlottesville, Virginia, at the University of Virginia.
By the time you completed your law degree, had you already been involved in law enforcement?
Right. So I started law enforcement part-time in '93 and did that for about 10 years full-time.
And where was that?
That was in Topeka, Kansas. While I was in law school, I was working narcotics at night. I went to law school during the day. So I actually got my law degree while I was working at the police department, still as an officer.
And were you certified as a law enforcement officer in Topeka, Kansas?
Yes, sir.
And did that require you to go through what we call academy training or that sort of thing?
Yes, sir.
And the kind of training you received at Kansas, was that the same or similar to the kinds of training that officers receive throughout the country?
Well, yes, obviously, the most basic patrol tactics things. We were actually I would say we were doing back in the 90s some of the things they're just now starting to do in a lot of the country, so they've sort of caught up, because Topeka, no thanks to me, was way ahead of its time. So the short answer is yes, what we're doing back there is very reflective of what's happening now.
What has been the value, if you would, very briefly, to your current position and your consulting that you now do, of the academic background that you bring to the table in every case?
Well, the academics that led to I would say the experience side. So my jobs, when I left the police department, I ran our defense tactics program. I ran our de-escalation program, communications, but more than that, I worked with attorneys in that capacity, bringing the operational side, where we would do joint presentations. They would talk about the law and I would talk about the application. So I had that experience based on my experience and my early, I suppose my bachelor's degree probably allowed some of that. Once I got my law degree, I was doing more of that, so that was beneficial. Ultimately, when I was practicing law, I left the police department to become an attorney for the Army. I was a JAG and a prosecutor and a senior. We might get to that, but to your question, that education with the law degree allowed me to get into positions where I was a full-time legal instructor for police in constitutional policing issues. Large part was use of force. The jobs I held because of that degree, particularly the law degree, because there's very little police-specific law in law school, just the highest level constitutional standards at best. But what I was allowed to do was take that, my law degree, and go into positions and continue to prepare that allowed me to be a police legal advisor for maybe 5 different chiefs. So that was I suppose it was a key that allowed me to have those jobs. And then, like I mentioned earlier, there's a lot of that in my military career that I did domestically.
Well, before I get to military career for just a moment, I'll get to that next, but I do want to leave with this on this area. Are you a member in good standing of the bars of any state or other jurisdictions?
Yes, sir, Kansas and Virginia.
Are you also licensed to practice in some federal jurisdictions?
Yes, sir.
Now I want to talk about your military career and your work there.
Yes,
start with when and what branch did you go into?
I was an Army JAG.
And when was that?
I started in 2003.
And that was, JAG, for those who are unfamiliar, means Judge Advocate?
Judge Advocate General, yes, sir.
Okay. And the Office of the Judge Advocate General provides what kind of services to the military?
That's the law division. So if you hear Judge Advocate, that's just an Army lawyer.
And I think you talked about it before. From time to time, would you actually, as a member of the Judge Advocacy, your assignments would be to prosecute wrongdoing?
Yes, I was a prosecutor, a senior prosecutor, and also a special assistant U.S. attorney.
You jumped ahead of me there. And as part of that, did you also get an appointment as a special United States attorney?
Yes, sir, I did.
And did that enable you to prosecute cases in some of the federal courts of this country?
Yes, sir.
And did you do so?
Yes, sir.
As part of your military assignment, did you ever provide services directly to the Pentagon?
Yes, sir.
Tell the court about your assignment at the Pentagon.
So I was the senior domestic operational law attorney, and what that means is my job was to identify the rules for use of force, which are the rules that if the military operates domestically in the U.S. and they integrate with civilian law enforcement, we had to look at what the civilian law enforcement rules were and what the military rules would be that allowed them to integrate. Most people think the military operates only overseas. When we operate overseas for use of force, we operate under what's called rules of engagement. When we operate domestically, we operate on what's called rules for use of force. And so my job was to evaluate the policy that applied to, I think, over 1 million service members when they operated domestically. So I actually reviewed and wrote the DOD policy for use of force and also the Army policy for use of force. DOD.
DOD, Department of Defense.
Yes, sir.
And those policies were, to your knowledge, many of them enacted and became the rules of engagement for the military police.
They were the rules for use of force and for the military police, yes.
And I think you've used the term domestic operational law. Domestic operational law interfaces with military law in what way?
Well, the domestic operational law, a lot of people don't realize on military basis we have civilian police, we have contract police, and we have military police, all enforcing civilian laws on those military bases. When we operationalize those units to work with the civilian populations, we have to be able to integrate our rules with their rules, our training with their training. So my job was to make sure that we understood what our limitations and capabilities were. We understood where we could and could not integrate with the civilian population. And that required me as the lawyer to know intimately what their rules for use of force were, what our rules for use of force were, where they might have differed, and where we would have to deconflict them.
Moving in another direction for just a moment, have you served as a professor or an adjunct professor at any law school?
I worked as the legal instructor at the military police school, where I was full-time legal instructor. I have not worked at a law school. I've been an adjunct teaching law at universities for undergrad, and also full-time at the military police school.
And in doing so, since it wasn't a law school, in doing so, what was the focus of your teaching?
Well, I would broadly call it constitutional policing. That meant the broad spectrum. So it was confessions and admissions. It was use of force decision-making. It was search and seizure. It was investigations and the operational application of search and seizure rules.
In addition to all that you already told us, have you been invited to lecture and instruct at symposia, nationwide conferences, even some hemispheric conferences, on subjects related to the application of force, the action-reaction gaps, and the best or the appropriate practices and policies for law enforcement agencies?
Yes, that's actually one of the largest parts of my job now. Is that's a monthly and sometimes multiple monthly thing that I do.
Just to give the course some perspective on this, you recently lectured at an international conference, correct?
The International Association of Chiefs of Police Conference for their legal section, so I trained the attorneys at the IACP Legal Officers Section Conference recently.
When force sciences or your teams are studying or investigating lethal uses of force, do you consider factors like biofeedback, physiological and psychological factors, and frankly, human factors in decision making?
So the first one I'd say we don't consider when you say biofeedback. So that's a technical term. So what I will say is what my job is to help investigators and attorneys identify what we call the psychological, physiological, and environmental influences on perception, cognition, and decision making. In other words, during a critical incident, we can expect certain things and to look for certain things that a human in that event is going to experience, and that's going to affect their ability to see, to understand, and to perform during a critical incident. My job is to identify what those potential influences are, and then to identify potential experts who may come in and discuss the science behind those particular practices. But our job is, my particular job, because we do have researchers and scientists, my job is to identify the potential influences and then to investigate what evidence is consistent with those.
In addition to that, have you published materials in forms of newsletters or other things directly related to policies and the proper uses of various types of force by law enforcement agencies?
Yes.
And could you just give the court some idea of how many articles you have published on specifically addressing law enforcement agencies and their policies?
Well, policies relative to use of force and sometimes broader de-escalation policy development in two ways. One, before I was at Force Science, I worked for a company called Lexipol. It's one of the largest public policy development companies in the country. And my job was a senior policy advisor. So I would write curriculum and also write articles reflecting the rationale behind certain policy considerations. When I came to Force Science as the executive editor of Force Science News, my job is as a translator. I basically look at industry-wide research, and sometimes our own research, but mostly industry-wide research. And I would look at the findings and the operational application of those, and then would write articles. I've written hundreds of articles at this point that are both published in our newsline, which is an online newsline, but almost every one of those is republished in other professional publications, magazines across the country and sometimes internationally. So it gets much wider distribution than just ours, but that's a constant part of my responsibilities as well, is to author those articles.
And has some of your work and research been cited in chapters or in chapters within books addressing the uses of force by law enforcement officers?
Yes, sir.
And have your publications, at least in part, addressed matters like the importance of action-reaction training for law enforcement officers?
Yes, sir.
We've been using this term a little bit loosely, but just to stop for a moment, I'd like you to explain to the court, when we talk about action-reaction training, what are we really talking about that's not a term that laypersons like myself would understand necessarily.
No, when we're talking about two things. We're talking about a threat assessment, and then part of that threat assessment is if this person decides they want to attack us, are they in a position in which they could do so based on our position, our relative position to them. So action reaction could be not just how fast can they attack us, but what is my window of responding to it? And that window of response is directly affected by how close I am, whether there's barriers, how fast they initiate the assault, how fast I recognize the assault, make sense of it, and then make a decision, and then actually execute that decision. Both take time. And so depending on the nature of the assault, the amount of time or opportunity they have to execute that assault is impacted by, again, those psychological, physiological, and environmental influences. So the action-reaction issues, we have to overcome the myths that we talked about earlier. Sometimes people think that I'm standing far enough, and we're thinking you're not standing far enough, right? And we can demonstrate those types of issues. Other times we think, we will frequently see, as I mentioned earlier, they think they have a tactical advantage. We'll be able to show them from a response time gap, you need more distance or you need more time than what you currently have. So that's what we're looking at, is what are the influences on the attack and your ability to respond to it.
And is action reaction something that you've observed being taught throughout law enforcement in the United States?
Yeah, since the beginning. I actually started maybe 1990, and I started to see it then. Action reaction is almost in every single policy. It's almost every single training. It is a well understood concept in police. We see it reflected as simple things like maintain what we would call a reactionary gap. Don't stand too close to the person that you're talking to, so that if they do decide to attack you, you have at least some time and opportunity to recognize that they're doing something, assign meaning to it, and then and then decide what you want to do, and then execute that decision. So from the beginning of your FTO training,
FTO,
field training officer training, your initial training, you're learned don't stand too close, maintain a reactionary gap. It's as simple as that. And then with additional weapon systems, it gets more complicated. How to create good reactionary gaps is a big part of tactical training these days.
And since joining Force Science, have you supervised directly the review of policies, procedures, and training that's been used by law enforcement agencies all over the country?
I would say, well, yes. So the biggest example I can use is I wrote articles and evaluated and analyzed de-escalation training, the operational version of de-escalation training, and those concepts that were identified in that article series were then subsequently adopted by many agencies and became not maybe the full, but portions of and baselines for a lot of the changes that we saw across the country, yes.
Have you previously served as a consultant or an expert witness in litigation in criminal or civil cases arising out of incidents of use of force by law enforcement officers?
Yes, sir.
In some of those instances, have you been required to provide testimony that is relevant, reliable, and sufficiently tied to the facts of the case to be helpful to the jury?
Yes, sir.
Have you ever been disqualified by an expert or had your opinion stricken by any court?
No, sir.
And have you done so on behalf of both the state and the defense in criminal cases, and the plaintiff and the defense in criminal cases, and the plaintiff and defense in civil cases?
I'm going to be very careful here. As a litigation consultant, I've been hired as an expert litigation consultant for plaintiffs' counsel, defense, and civil cases, and both prosecutors and defense in criminal cases.
Okay. And in every case where you have testified or for which you have given consulting advice, have you dealt with the issue of human factors and the best police practices best police practices as it relates to self-defense or the defense of others?
Yeah, and I'm going to push back again on that word best. That's okay. Only because it becomes one of our issues. Is what my job has been in those cases to identify and to train investigators to look for evidence consistent with the potential influence of those psychological, physiological, and environmental influences. So the answer is yes, every single case, that is a big part of what I have to evaluate, and also train the investigators and also train the attorneys to evaluate on those cases.
And have you previously served as an expert witness or a consultant in cases brought in either the civil or criminal courts of the state of Florida?
Criminal courts, yes.
And in the cases that you have testified, have you been permitted to render opinion testimony related to law enforcement practices, the proper uses of force by law enforcement officers, and the constitutional or statutory standards of reasonableness?
The best answer is some courts allow it and actually request it, and other courts let me know up front they do not want me to testify to that. So the short answer is yes, in some cases I've been asked to render an ultimate opinion. Other cases I've been limited in that final assessment.
And of the opinions about which you are going to testify today, will they be based upon a reasonable degree of certainty in the field of force science and police practices?
Well, force science is a business, so I'm going to say that it's based on my experience as a police practices expert, as a professional practices expert. I'm not a scientist. Force science as a company will look at the relevant research that applies in use of force cases, and I will certainly have looked at that same research that is reasonably relied upon by experts in my industry, and considered those findings in evaluating threat assessments and ultimately responses, and then comparing that to, I won't say industry standards, but what we typically see across law enforcement and training and operations.
In the summer of 2024, was force science retained by the Okaloosa County Sheriff's Office to provide services?
Yes, sir.
And what were the terms of your initial retention? What were you originally in the summer of 2024 asked to review?
We were asked to review their firearms training program, their use of force policy, and we were specifically asked not to evaluate any specific cases. We were just looking holistically. They had a couple of back-to-back uses of forces, and they wanted us to come in, evaluate their current training program, evaluate their policies, and then give a presentation to their trainers on the firearms, their actual firearms instructors, give a presentation to their trainers, and ultimately give a presentation to their command staff.
And as part of the work that you proceeded with on that retention, did you actually review and physically watch the training and the training procedures employed by the Okaloosa County Sheriff's Office?
We did.
In fact, even seeing some scenario trainings?
Yes, sir.
Which are sometimes called shoot, don't shoot, that sort of thing?
We saw simulation trainings. Yes, sir.
And did you, in fact, complete that kind of policy review on behalf of the Okaloosa County Sheriff's Office?
Yes, sir.
And did you publish and submit to the Okaloosa County Sheriff's Office about 240-page report of your findings and policy recommendations?
With attachments, it might have come to that, but the short answer is yes.
Was there a time at which, however, your original assignment and the terms of your retention were somewhat changed?
Yes, sir.
Were you asked to then review on behalf of the Okaloosa County Sheriff any specific incidents that had occurred in the recent past?
Yeah, specifically when the two shootings that had just occurred, we were given evidence of those shootings only to identify issues and to be able to discuss specific issues that were present in those cases, but not to review those cases or relitigate those cases internally. We were under the impression, and that was clear guidance to us, so we did not do that at the time. We were aware of the cases, we were aware of the issues, and we sort of built our training around identifying what those issues were so that we could address them obliquely without reopening their internal affairs investigations.
And did it come to pass that you actually did review a case involving a shooting May of 2024?
We reviewed a very specific aspect of that shooting. We were given evidence sufficient to do that. The way it happened, our understanding was that when we went into that room, we were doing a quality control, quality assurance investigation, which meant, in our understanding, it was going to be privileged, it was going to be confidential, and they were going to be able to use it for lessons learned. We weren't trying to evaluate a specific case. When we got into the executive team meeting,
So we're clear, this, would you say we, this would be you and your team?
Right, I came with Mike Masengo, who is our firearms and training expert in terms of the tactical side of things. I came in as the policy, legal, and operationals expert. So he was looking at their advanced instructional methods and making sure their actual training methods reflected best training methods. I'm happy to say best practices in teaching. And myself and then my paralegal were there. So when we went to the executive team meeting, that's when the sheriff joined us, his command staff. I think there was an attorney present, at least by phone. And that's sort of where we sat down. The sheriff then specifically asked us.
You want to object for your side?
It's not for the truth of being asserted, it's to explain why he went forward to do what he did.
Well, I don't also object to relevance of this meeting with the sheriff, so.
Please approach, let's talk procedure for a second.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right.
Your Honor, I want to digress from my last question just for a moment.
Yes, sir.
At this point, Your Honor, I would request that the witness be allowed to give opinion testimony to the court.
Any questions, any voir dire on the witness regarding that issue?
No, Your Honor.
All right. You may proceed.
Now, I think, and if I'm repeating myself, I apologize. I think in the summer, I had asked you out in the summer of 2024, Force Science was retained to provide services, and you were explaining, I believe when the objection was made, that you were explaining how you got your assignment as it related to this particular case.
Yes, sir.
And if you could explain to the court now, I think more fully, how is it that you came about investigating this particular case of the shooting in May of 2024?
Sure. The facts of the shooting were provided to us in our initial review to help us issue spot so that we could prepare our training against some of the issues that arose in this case and another case. We were specifically asked not to evaluate this case, to relitigate it internally. When we got into the meeting with the sheriff, he specifically asked us to talk about this case, at which time I asked the attorney in the room, we understood this was to be privileged, we were not to discuss this case. If we feel like this is a privileged and confidential setting, we can talk about the good, the bad, and the ugly is how I framed it, because in my estimation, this case had a little bit of all of that. They believed it was a privileged communication, it was confidential, and in that context, we moved forward analyzing this specific case with the sheriff and his team.
And later, just to fill in the gap here a little bit, at some point was it determined by the sheriff's office and their counsel that this was such that you actually were deposed in this case and have given testimony by way of deposition in this case already?
Yes. Let me be clear on that, I'm sorry, if I could. When we were notified of the deposition, we were notified first if we would be willing to, I think, sit with an interview with the defense counsel. I contacted the sheriff's legal representation and said, my understanding is this is privileged, do you guys intend, it's their privilege, so do you intend to exert that? And after some deliberation, they got back and said that the report had already been released and that we were free to testify truthfully about that report and the conversation surrounding that report.
All right, let's start off with a little bit about the information that you received. You received all the information in this case from whom? About this case from whom?
From the Okaloosa Sheriff's Department.
Okay. And did that include investigative reports?
Yes.
Some interviews of witnesses? The kind of materials that you would normally review in cases when you were asked to step in and review a case?
It had quite a bit. I believe it had enough for us to evaluate the issues we were asked to evaluate. It had the body cam footage, it had the final IA investigative report, internal affairs investigative report.
Just to interrupt you, and did that include also an interview IA interview that was conducted involving Deputy Duran?
His statements were included within that final report, yes.
So you had Deputy Duran's statements, were you provided statements of witnesses? You don't know who all's been called here, but they would be people who started a series of calls that day that resulted in the dispatch. Did you get all that kind of information?
Yes.
And do you believe that you got enough information from the sheriff's office to allow you to formulate an opinion or opinions about this case?
Yes.
And who participated with you in the evaluation of this case?
Mike Masengo.
And in your consideration of this case, had you also reviewed and did you continue to review the ways in which the Okaloosa County Sheriff's Office trains its officers?
You're talking in conjunction with?
In conjunction with the other study you've talked about?
Yes, sir.
So you were aware of the methods that are being used and what is being taught by the Okaloosa County Sheriff's Office as of when you began your investigation in 2024?
Right. We went to the Sheriff's Department and we actually personally observed their training, their firearms training, and their simulations training, and that snapshot is what we had. Yes.
And did you eventually agree to provide opinions to the sheriff's office regarding the shooting that took place on May the 3rd, 2024 at the Elan Apartments?
Yes, and I will say how that came about. We were asked, when we evaluate these cases, we provided them our method of evaluation. We were asking two basic questions. Was the threat assessment reasonable? And was the response reasonable? And reasonable, understanding that reasonable people could disagree. We made that foundational clear. Reasonable people could disagree. It's an educated assessment. They have to be reasonable, but ultimately forensic evidence may later show they weren't correct. But we were analyzing this and the case facts for evidence consistent with a reasonable belief in an apparent threat of death or serious bodily injury. We laid out that methodology for them, which I'm happy to get into if you want to follow up. But once we reviewed that methodology, the only thing we were asking or answering specifically is, did he pose, was it reasonable to believe he posed an imminent threat of death or serious bodily injury? And I can tell you our methodology for getting there. And then ultimately, was his response consistent with that belief? I rendered opinions on both of those questions.
Well, I think that at this point I'd like to go just to specifically the opinions. You've had the information, you reviewed the case, and you came up with opinions. I want to know for you to give the court the methodology you used in arriving at the opinions as to the reasonableness of the conduct, and what factors you gave weight to.
Sure, and that's going to be a lot. So the first is the imminent threat analysis, and we use a structure, and it's a structure that's used across the country, and it's been, since the 70s when it first started being used, I think. But it's an imminent threat analysis.
I'm going to object to discussion of the imminent threat analysis. This is obviously the purview of the jury, and in this case the court, to decide the imminent threat. And this was kind of my concern, and with the overlap when we're getting into the witness explaining what may be confusing to a jury in terms of what the law and standards are.
I'll reserve ruling on the objection.
Yes,
you can proceed with your answer.
So there's a structure for analysis, Your Honor, there's variations of the structure, but the one we use is intent, ability, means, opportunity, and it's intent or willingness to use death or to inflict death or serious bodily injury. Physical ability, means is a weapon system. It could be hands, fists, feet, teeth, or an actual knife or gun. And then opportunity is this: if they decide to execute that decision, does the environment allow that to occur? So when we do the imminent threat analysis, we're looking at the case facts for evidence consistent with intent, because a lot of it is circumstantial evidence. So I will walk through the case, look at the facts, and say, what are the facts that are consistent with a reasonable belief that? We don't speculate to actual intent. We don't actually, we stay very clearly in the reasonable belief standard, not what they ultimately later learn. So as we analyze that, we would go step by step with what evidence was consistent with intent. And part of that goes heavily into police practices. That's what are police trained to consider, because they don't know, they're not required to know. It's just what are they trained to consider. That training and what they consider, we frame that as it's going to be relied on, it's going to be based on their training, education, experience, and then reasonable inferences. Police practices experts really spend a lot of time on what does this mean to a police officer. In civilian cases, it's what does this mean to a person familiar with violence, right, and the reality of violence. So we just walk that through, and we talk about a reasonable officer could believe or would be trained to consider the following possibilities. We did that, and I don't go through the whole analysis, but at the end, in this case, the framework came down to, does this person was there evidence consistent with a reasonable belief that he had the apparent intent to, or willingness to inflict death or serious bodily injury? I think that was the only real question. The physical ability, he's upright, he was mobile. The means was a present firearm in his hand. And the opportunity was time, distance, and speed. There was no barriers. There was nothing preventing him from shooting that officer with an operational firearm, or at least reasonable for an officer to believe he had the apparent ability to inflict death or serious bodily injury. The question then became really centered on intent. So for us, in our analysis, now the agency threw in a little wrinkle, because they're more restrictive in their policy than the law requires in one specific area, which I can talk about in a second. But the intent aspect was, what does it mean to a police officer in the context with which this officer was operating? You want me to go to specific facts? Or?
Let me back up and kind of go chronological with
Yes,
you
sir.
just a little bit. So let's start off with this. Did you find that that there was a reasonable belief that on the part of the officer that he was responding to what could be a domestic disturbance?
Yes, sir.
And if you could, I think that this has already been covered with the court a little bit by some of the officers, but generally, what nationwide and specifically here, what are the dangers inherent for a police officer when they are responding to what's reported as a domestic disturbance?
Yeah, so some of them are probably common sense, but there's a lot. One, they're the most unpredictable and uncertain types of calls because you have two people who have known each other for a long time. And while they're arguing, when you show up to those calls, there's a lot of history, a lot of emotion, there can be a lot of violence, right? And it's not just violence against each other, but a lot of times when police show up to these domestics, both sides will ultimately turn on the police officer. And so there's an inherent risk that you show up trying to save a victim from the abuser, and they both end up turning on you. That's common knowledge among police, right? It's something to be aware of, or police are trained to consider. Domestics are occurring in somebody's house where it's just a familiar environment. They know where the knives are, where the guns are. It's their private space, so there's an inherent sense of protection of that private space. Police are trained to consider that when you go into someone's home, it is very off-putting to start telling them to do things. Please have a seat over here or stay out of your kitchen. So there's an inherent tension built into domestics because you're in their space that they're familiar with, and you're going to have to exert control in that space, which is very difficult. Those are places that are renowned for violence, right, against police officers, attacks, ambushes. So those are things you're trained to consider. And it's not that you know those are going to occur. Again, I'll frame it very specifically. These are things police are trained to consider in responding to domestics.
Did you find that the response to the dispatch was an appropriate response by the deputy?
Right, and specifically when you ask me about response, what I'm thinking of, typically in a response to a domestic, because of the inherent threat built into it that we just discussed, you want to take additional back units with you. It's not something you typically want to do by yourself for all the reasons I just mentioned. When you have, or you reasonably believe there is an immediate threat to the safety of another person, meaning there's violence going on right now, right? You don't have containment, you don't have control, you have ongoing violence. Then the officer has to make a tactical decision whether to wait for additional back units or to go what I would refer to as direct to threat, which is I think the same language that was used in their report. It was a concept that I was familiar with, and so when I heard it, direct to threat just means while we might ordinarily wait for a backup officer, the risk to individuals, the risk to innocent persons is so great that officers are expected to assume the risk on themselves and go direct to the threat. And so they'll bypass what we might ordinarily think is a safer option to wait for back and go straight in to assist and investigate that potential violence.
Did you find that the officer's decision to respond after being dispatched and after speaking with the person at the scene, that his decision to immediately respond was an appropriate one under the facts that he had?
Yes, it didn't surprise me. It was consistent with what I would expect a police officer to do when you have that duration of an argument going on. That was important to me. This was going on a long time, and it was kind of getting somewhat real-time reporting by the neighbor. But the duration of it, and then the fact that it was described as getting handsy, I think, that is something an officer would reasonably consider as evidence of an ongoing immediate threat. So it did not surprise me at all that he went direct to threat.
Did you find, you've already told the court that among the things you reviewed the video that was on the body cam.
Yes, sir.
Did you find that the body cam gave you additional information that helped you in making your decision as to the reasonableness of the conduct?
Well, it does, right? So what the body cam provided was some idea of what the environment looked like relative to where the officer could stand, relative to the door. Those types of things were important. The elevation was important, that you're 4 stories up. So there was a lot of things that you could see that when he knocked, where he was positioned when he knocked, how he knocked, what he said while he was at the door. All those things were captured on the video.
At the time he arrives at the scene, if I recall, and if you can explain, there appears to be that the officer is listening for a period of time to the front door.
Yes, sir.
Again, is that consistent with the training?
Right. So you have a choice, and I'll say this maybe a couple of times, but tactics are discretionary. So there's risk, benefits, and trade-offs to each of these decisions. So sometimes when you go direct to threat, you want to gather as much information as you can. So you might just go there and listen, and we kind of like look, listen, and feel, kind of you would with a house that you think might be on fire. So when we're training it, well, like, especially with a domestic, your first arrival, you might want to pause, look, listen, and feel before you make them aware of your presence, so that you get a sort of a natural sense of what's going on, absent the pebble in the pond, right? Your presence. And so it doesn't surprise me if an officer shows up, listens for a second to gather more information, so that he can relay that back to dispatch, have my back unit step on it, it's active, whether they need to force entry or knock, all of that is based on the additional information they have when they get there. So it's a tactical decision, and I understood it, and it was consistent with those principles.
The initial complaint was of an ongoing dispute upstairs, and then someone else passed on that information, and then dispatch picks it up. When he arrives, it appears that there's no sound initially.
Right.
He continues to proceed. From a perspective, was that an act that was reasonable under the circumstances to continue, even though you didn't hear anything?
Well, it would actually heighten your concern at that point, because if you have a long, ongoing domestic that you believe is violent that suddenly goes quiet, and police are trained to consider several possibilities. One is she's gone by the time you get there. Put that on the whiteboard, as we say. The second thing is she's incapacitated and incapable of responding, because whatever that violence was is now, she's unconscious a lot of times, or sometimes. So you're in your head, you're thinking, why did the violent domestic suddenly go quiet? And that is your biggest concern. There's a whole host of reasons why it might go quiet, which is why the police have to investigate it. It might be something simple, in fact, yeah, it could be something simple, or it could be something heinous, and you don't know until you investigate.
The first knock is a knock that he makes on the door before announcing he's with law enforcement.
Right.
Do you find that to be consistent with the training and best practices of the department?
Yeah, well, I'm going to step away from best practice again. I'm looking for
police practices.
I'm looking for reasonable options. There's a bucket where officers may do different things. Again, it's tactical discretion. There's risk, benefits, and trade-offs. So I can tell you what the benefit of that would be. One of the benefits is if you knock and not announce yourself as the police, you run the risk, if you announce yourself as the police, you run the risk of escalating whatever's going in. If now all of a sudden they know you're the police, if they're going to take a hostage, they're taking a hostage. If they're going to hurt somebody, they're going to hurt somebody. Announcing your presence restricts that person inside's window of escape or avoidance consequences. As soon as they know the police are at the door, it changes their behavior, and it could escalate it. The other thing is, that's why you look, listen, and feel without announcing first, right? The second thing is if you just knock, which is a tactical decision, the benefit is you're doing what's called a compliance check. How are they reacting to a knock at the door, and is that going to provide me additional information relative to the threat or potential compliance? If you knock and it's like, who is it, right? You understand that whatever this violent ongoing domestic is, the reaction is inconsistent with my understanding of a violent ongoing domestic. That's why you might knock and not announce yourself first. Obviously, each of these, another officer might have gone up and knocked and announced himself immediately, and that would also have been a completely appropriate tactical option. But there are benefits to doing it without, and there's also risks.
Yeah, and after the first knock, I think you did an analysis of each of the knocks, correct? Kind of what happened or what happened
Right.
next. After the first knocks, were you provided information in which you had some belief that the officer was aware, that someone inside the apartment was aware of an officer's presence?
Yeah.
Don't repeat what you've heard. Just, were you provided information that gave rise to your opinion that the officer was correct the officer believed somebody was inside the apartment and he was unwelcomed?
Your Honor, I would object. The witness reviewed as he mentioned, the IA statement from Deputy Duran. This goes towards the bolstering aspect, and bolstering Edward Duran's testimony in terms of his knowledge as he's standing there at the door. I would say it's inadmissible, it's hearsay, it's self-serving, plus the fact that it's coming from a Garrity statement, which is inadmissible even for the prosecution in a criminal case.
I'll reserve.
Let me back up. Did you find information from sources other than the so-called Garrity statement, other than his statement? Was there other indications to you that the person inside knew of the presence of the police officer?
Yes.
And Judge, I guess I would object because there's a deputy that gave his opinion, Deputy Hernandez, that was one of the other motions, that he gave his opinion about what he heard and generated a report to it. So,
I'll reserve.
Yes, sir.
And I would just, for the record, point out that an expert is allowed to rely on information in formulating an opinion. We can't transmit that information, but he can rely on information that's not otherwise admissible in formulating an opinion. And the law in Florida is pretty clear on that. Now, moving on, we're also from your own experience watching the video itself. Was it clear to you that the officer had done the right things in terms of announcing his presence?
They were consistent with police practices. They didn't surprise me. Then I understood why he did what he was doing. I understood the benefits of why he did what he did.
Now, let's just assume for a moment, if you would, that we don't know what the guy inside knows or doesn't know. From the police officer's perspective, what does he have a right to expect once he's knocked and announced twice in a loud voice?
Well, if I can use the analogy of what he can expect is that or reasonably believe is that the person inside now knows he's the police. And the best example is that why we do knock and announce warrants, right? The requirement to knock and announce is that if you knock and announce your presence, you have provided adequate notice to the people inside that it's the police that are coming through the door and given them an opportunity to respond. It's the same concept that when you knock and announce, particularly in an apartment complex, it's reasonable to believe that the people inside heard the knock, which you'd know if they come to the door that they're responding to something, and simultaneously also heard that you have identified yourself as the police and so now are aware that you are a police officer.
Now let's move to the kind of, he's knocked a second time, he's knocked a third time, and almost immediately thereafter, the door begins to open.
Right.
Did you review the video, the video from the moment of the door beginning to open till the shooting itself?
Yes.
What are the things that you focused upon in trying to make your determination as to the reasonableness of his conduct?
Well, when we evaluate cases or train people to evaluate, we're really more interested in their statement, their perception of when they perceive the weapon rather than when we can see it on a video.
Your Honor, again, at this point, I would object to hearsay and bolstering in terms of the witness statements, or the defendant's statements, I'm sorry.
I'll reserve.
I think you were saying that one of the things you focus on is when they would see it as opposed to when.
Right.
Why is that? Explain to the court why there may not be a video at the same time that someone's eyes make contact with difficulty.
So one of the things we spend a lot of time training is this, kind of almost tongue-in-cheek that videos are liars. And what I mean when I say videos are liars is that they do exactly what they were designed to do, and that is to change angles, distance, time, and speed, or speed, distance, time, and angle, in a manner to collect more information than the human eye could collect, right? So it's trying to gather more forensic evidence. So there's a fisheye lens or there's a barrel lens. So that's going to distort the scene in a way that the human eye is not going to perceive it. So we do not ever watch a video and use the video as a proxy for the officer's perception or the officer's experience. We've done research specifically where we put eye trackers on officers and body cams, and we put them in the exact same scene, and then we compared where was the officer looking, where are the eyes aligned with what's the body cam picking up. And there are scenes where the officer's not seeing anything on the body camera at all, because the easiest one is if the body cam's looking straight and you've turned your head to the right. We cannot look at a body cam and assume that an officer saw anything at any one particular moment, not just because of head alignment, but also because what you're paying attention to. If I'm paying attention either internally, thinking about, I wish I wasn't here right now, you're probably not perceiving anything, even if you're looking at it. We're all familiar with looking without seeing. And so when we watch body cameras, we do not ever assume in any case that anything we're seeing on the body camera was perceived by the officer. We have to rely on the officer's statement for that.
And based on the perceptions that you have read, that you've been provided by the department, as well as the body cam, which you have reviewed, at what point, let me back up a second. Does proximity to the encounter make a big difference in the reasonableness of the response?
And Judge, I'm sorry, I don't want to interrupt there, but as it goes to my last objection, and the witness clearly just stated that they rely on the witness statements and don't rely on video. So he explicitly stated he's relying on the defendant's statement as to his analysis of the video.
All right, I'll accept your renewed objection and I'll reserve.
Yes, Your Honor.
So I can follow up on that. You do review the video.
Yes, the video is a separate, independent piece of evidence. My testimony, if I wasn't clear, is that we do not use the video as a proxy for or a replacement for the officer's experience. The video certainly has incredible amounts of information and ultimately evidence that we would consider as well.
And I think the question that I just asked was, does the proximity, if you will, the closeness of the encounter have a determination, make a difference in your determination of the reasonableness of an officer's response?
Right, so back to the response time window, the window of the ability to respond, distance is one of the biggest criteria for that. Depending on the weapon system, distance is going to change. You can be in a lot of danger at far distance with a gun. You're going to have to be closer for a knife or an edged weapon, for example. But distance is one of the biggest things that we consider relative to opportunity.
And in terms of within, say, 4 to 6 feet, what kind of options does that limit someone to when they're making an encounter?
With a firearm?
With a firearm, yes.
They are close enough to be shot instantly without any obstructions.
May I have a moment here?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398.
All right, so based upon council request, we'll go ahead and take our lunch at this time. We'll reconvene at 1:15.